No, I love it. Well, it's also the iceberg is like.
So are you saying putting some Adam
What is that kind of wheat that you get with selfies that is like shaded like this? What is that? A Korean leaf that you could shaped like this. Oh, what is this? That's all I know. What's in this
I saw有一下是搞历史，然后历史跟我那个跟自己聊，我就是会参加个部门，然后这个人
Oh yeah, Hillary was like rocking it.
Where else is going to go? I'm not going to die. Well, obviously. 你以为不是就有录像出来，没录像是在办公室待着。还 smart board smart board 就是可能用的黑板什么的，我碰到你们技术的那个，其实也是很简单的。
We're talking about Koreans here, and they're both Koreans, so they're laughing.
I 我跟你说今天会说，我当时也跟他说了才说。挺好的，讲的挺好的。但是你出来讲，我怎么办呢？有那个模拟谈判的，就是要演我在这个我怎么太有点难，跟不上他们这个。 就我的内容，所以我看我也是选这样，然后后来第一节课去听了嘛，就跟教授上教授没关系，我帮你弄。改过呀。其实我当时应该可以吧，那条不是好的。你可以跟教授说一下。
Wow. Then let's start. Everybody ready? Good afternoon, everybody. Welcome to the first Cox Center presentation of the semester. We've got some other exciting things coming up. In March, we have David Tolbert, who is the president of the International Center for Transitional Justice, giving a speech. It'll be at the City Club, and we'll have buses that will take you over there, and we'll send emails out to you so that you can register for that in advance. At our Canada-U.S. Law Institute conference in April, we're going to be launching a new non-governmental organization, and the conference is going to be so big that we've moved it over to the Art Museum, and it's free for students, so that's something to look forward to. Next Wednesday is the Jessup Moot Court Team Night, and we have 3 of the 4 people that last year took us far into the international rounds and won Best Brief and Best Oralist Awards coming back, and I saw them. Oh, there's a couple of them are in the audience today, Kate and there's Hyder. But you'll be seeing them on Wednesday evening if you come to that, and it's going to be fantastic. They're very ready, and they're going to do better this year than ever before. Which is saying a lot since we won the World Championship in 2008. But today, we're going to be talking about something that is an issue that is ripped right from the headlines. If you've been reading the newspaper, you know that things in Libya are hot, hot, hot. Hillary Clinton just testified earlier this week, and she got into all sorts of clashes with the Congress over who knew what, when, and where in relation to the attacks on Benghazi. Now, I myself have been doing work involving Libya through my Public International Law and Policy Group, which is the NGO that I run together with Paul Williams. And this summer, I was in Libya for 10 days. I was in Misrata, Zawiya, Zawara, Tripoli, and other places, training the people who are going to be involved in transitional justice. But today, we have one of the all-time Libya experts, and also a military expert extraordinaire, and a very good friend to the law school and to myself. So I'm going to introduce the speaker, Michael Newton. He rose up through the ranks after graduating from West Point as a Judge Advocate General. He was a colonel. He was a JAG officer in both Iraq and Afghanistan. Later, he taught at West Point. He then joined me in how we got to know each other very well as one of the elite 5-member group that trained the judges for the Saddam Hussein trial. We did those trainings in various places around the world, but Mike ended up going to Iraq and spending time working with the judges during the trial, sort of whispering in their ear to try to keep things on track. And the two of us have written a book about that, which if you're ever interested in knowing anything you want to know about that trial, warts and all, you can read. It's called Enemy of the State. But today, Mike is going to be joining us to tell us about everything we should know about Libya, probably things that relate also to Syria, and I'll be just sitting on the sides and chiming in from time to time with my experience as well. So without further ado, please welcome Michael Newton.
Well, there's your quote of the day, and now you can go to sleep. Libya is hot, hot, hot. Yes, true. And in fact, it is also true that Enemy of the State makes a great Valentine's Day present. So today, what we want to do is I'm not just going to blast through slides. I have a ton of slides, and I'll give these, of course. Anybody who's here, Professor Scharf, has these. and you put them in PDF, and you're welcome to send them around. I really do want to have a conversation, in part because of Professor Sharf's experience and our experience, and we've learned that we complement each other very nicely. So if you have questions, I really do want to have a dialogue, right? I'm a law professor. I could rattle at you for an hour. That's not at all our intent. So I really do want to have a dialogue and where you have something. Here's the takeaway, though. I think there are three big questions. You all look at Libya from the outside, and you look at Libya from the perspective of what happened. But more importantly, you look at it prospectively in terms of what does this mean for me as an emerging young professional, as an emerging young lawyer. And I think that's, from your perspective, what's really important about Libya is what does it mean to me, and how do we learn from it? What do I do in the future? Three big takeaways that I want to talk about that I think are really relevant for you to take away and to really think about. One is the way we do bureaucratically. Professor Sharf mentioned Syria. So mistakes in Libya are being replicated in Syria. No question. We have not learned. We didn't learn from Kosovo. We didn't learn from Iraq. And so we want to talk a little bit about those so that one day when one of you is an Assistant Secretary of Defense, you can fix those problems. Or the Undersecretary of State to bureaucratically restructure the way we do it. The second big issue is the U.S. domestic war powers debate. How many folks are working on the Journal of the Symposium issue? That's going to be, I think, that's going to be the single best collection of war crimes debate pieces around in terms of recent updates. But the war powers debate in the United States was fascinating, has huge implications, again, for Syria, for Iran, for a whole other set of potential conflicts, which we need to learn as a political lesson.
Yes. Is there anybody here who doesn't know what the War Powers Resolution is? Raise your hand. Don't be afraid, please. It's a little bit obscure. Okay, so you may have to start with that. We have a lot of visitors.
That's true, and I stand corrected. The War Powers Resolution deals with the domestic allocation of war-making authority. Big debate in the Constitutional Convention. Does the president make war or declare war? What's that relationship between our domestic, executive, and legislative branches? George Washington learned that lesson, and that's why the Constitution says that Congress declares war. The executive branch conducts hostilities and is, as you would say, the executive executes, is the verb. But that balance of powers in terms of funding and authority and domestic, the relationship of the president, the executive, leadership to the American people, and how we conduct hostilities abroad is very controversial. And Libya changed that dynamic in some pretty fundamental ways. And then the interesting thing will be what that means for the future. For anything from automated technology to drone strikes to air power to surgical strikes in Iran, for example. The Libya war powers debate in terms of U.S. domestic constitutional authority is affected by what happened. So, does that answer any questions? Any questions? Okay, and then the last one, which is near and dear to our hearts, Professor Sharf having been in Libya, I've been working behind the scenes on some of these other issues in terms of the court, is what happened with the ICC referral. Under Article 13b of the Rome Statute, the Security Council used its Chapter 7 authority to say to the court, we are creating jurisdiction in Libya for the International Criminal Court. Nothing controversial about that. But I'm about to say something that's controversial.
And before you do,
yes.
Your interjection, just so you know, we have a special program where when you're a third year, you can spend a semester at the International Tribunal. Last fall, one of our third years, Effie, who's sitting in the front row, was working for Judge Christine Vanderbilt at the ICC on this very issue. So as Colonel Newton tells us about the objective insights, perhaps Effie will share some of his own insights.
And we'll talk, a little bit later, we'll talk about the substance of the resolution. But here's my projection. So far in the life of the ICC, there's been a surprising, if you had talked to us when we were drafting the statute, nobody would have predicted the way that referrals to the ICC have actually happened in point of fact. A good example for those of us who have the hubris to think we can predict the future. Setting that aside, I'm about to predict the future. If the mistakes that were made in the Libya referral are not corrected, I think it's a pretty fair bet that you will not see another Chapter 7 referral to the ICC. point being that the Security Council has set up a structure under Article 13b in this resolution that is not capable of being replicated on the ground correctly. So you kind of have a straw man where they can refer it, but in point of fact, what that means on the ground for the ability to investigate and prosecute a case, and I'll explain this to you why this is true, it's not a sustainable structure. So you may very well have seen the last of those 13b referrals if this resolution mirrors.
Just to interject again, how many of you know anything or much about the International Criminal Court and its relationship to the Security Council? Raise your hand. Okay, so a lot of you don't. The way it works is that the ICC, the International Criminal Court, can prosecute cases involving the nationals of its parties. And it currently has 121 state parties. Also, it can prosecute crimes that occur in the territories of those 121 states. But what happens when a crime occurs somewhere outside of its state parties? The statute says that the Security Council can refer the matter to the ICC, and the ICC can then prosecute. Of course, the Security Council has to have a decision under Chapter 7. They have to have the concurrence of the permanent members, the United States, Russia, China, France, and the UK. But when that happens, as it has now happened twice, the first time being in the Sudan, involving Darfur, the second time being Libya, then the ICC can have jurisdiction over a country that's not part of its, that has not ratified its statute. And that's the background. So when Colonel Newton talks about the fact that we've had these two referrals, and he's basically saying he thinks after Libya there will not be any more referrals.
Unless the structural problems of that resolution are remedied. Remember that a Security Council resolution, a Chapter 7 resolution, the necessary predicate legal finding is that whatever's going on in that country is a threat to international peace and security, which requires a lot of political effort. These are political acts. My point is simply, and I'll give you the reasons why here in a minute, that political act of referring a case, using the current structure, the way we've done these resolutions, is not capable of effectively being utilized on the ground. So it's a political symbolic act, but if you're really looking at effective prosecutions, this is not the model. And I can explain that. I will explain that. Okay. Other questions? Mike? Okay. So I want to do a very quick, and this is particularly relevant for those who are watching the series. I know y'all are law students, but do y'all watch the news at all? Right? You're seeing what's going on in Syria. And this is hard for us because we're sitting from the distance just as we were in Libya. So I want to give you just a little bit of history, a little bit of law of war. I don't want to do too much substance here. But there's a teaching point, which is that if, and we were talking about this over lunch, if those crimes are not concurrently investigated and documented to the greatest extent possible, there is a huge amount of evidence that is lost. So the concurrent accounts of who's doing what to whom, the concurrent documentation of missile strikes and all those things, it makes it very difficult after the fact to go back and recreate that stuff. Particularly in a setting like Libya, where in places in the country there's more or less chaos. So this is why it's very important for practitioners, if you're ever a prosecutor, to link up with human rights advocates and domestic organizations in the very first minute. And behind the scenes, I hope this is what's beginning to happen in Syria. Otherwise, you're going to see the news and you'll see, well, 65,000 people were killed, and we can't prove that case. Why? Because we don't have the evidence. Okay? So here's what it takes to prove some of those cases. One is, and this is from Libya, that attacks are directed against non-military objectives. This is the basic principle of distinction. You're attacking lots of things that are not lawful targets, and you've got to have a documentation of that. Unlike Kosovo, our State Department never put together this kind of consolidated, centralized listing of those attacks. By date, by location, we didn't do it. And therefore, we, the United States, did very little to help any prosecutor, either at the International Criminal Court level or at the domestic level, to prove those cases. We sort of said, on your own. Okay? The second thing, obviously, are indiscriminate attacks. And this is the second cousin to the principle of distinction. The idea being that you may be attacking a lawful target, but you're doing it in a way that does not distinguish or does not discriminate between the lawful target and other innocent, other affected victims. And again, this happened to a great extent in Libya. Now, there's nothing inherently wrong, or incorrect or illegal about using an area weapon, even in an urban area, etc. But it has to be a very carefully calibrated decision. This is an example from coalition operations in Iraq, where there's an area weapon, this multiple launch rocket system, and commanders that say, okay, given this time of day and what we know about that area and that target, we can use that area in some parts of Baghdad but not others. Some strikes but not others. So what's important about this is the idea that you have commanders, decision makers, that are actually making decisions about what to target and how to target and when to target. And again, the point is that you have to document those things concurrently. Otherwise, all you know is 60,000 plus Syrians were killed. Well, who authorized it? Why? And how? And what attacks? You have to document that stuff concurrently or you've lost it. And then lastly, the basic principle of proportionality, the basic principle of law of war. This is right in the Rome Statute. I've underlined clearly and overall because those are the criteria where the Rome Statute in Article 8, Article 8.2b4, if you want to look it up, essentially modernized international law. If you look at the Protocol 1 Geneva Convention standard, it doesn't say that. But you have to understand the history. You have Geneva Conventions, then you have a lot of state practice, and what this standard does in the Rome Statute is to modernize that. It's the one single place where you find the definitive statement of what this principle means. Violated all over the place in Iraq, or in Libya as well. Okay? Now let me give you just a little bit of history to set the stage for some of the legal lessons. As you all know, this began with more or less spontaneous riots, beginning in the east part of the country, moving across, spreading into unlawful killings across the country. This is in the famous stage where Gaddafi made the statement, we will exterminate them. You know, anybody who opposes the regime, boom, irrespective of what you're doing or where you are or who you are. And so you can see the war crimes here. Okay, the war crimes, unlawful killing, intentionally targeting civilians, so there's that distinction problem, and lots of disproportionate strikes, all wrapped in the same price, mixed with unlawful property damage. Gaddafi forces did the same thing that you've seen in Kosovo and a number of other conflicts, where if you oppose the regime, they simply came in and burned you out. This was a key part, for example, in the Yugoslavia context of the Milosevic case. This was a key part in Kosovo of prosecuting Slobodan Milosevic successfully. But we really don't have a good catalog of all the properties that were destroyed and who destroyed them and why. See? And it makes prosecuting these cases extremely difficult if we want to do it based on law. The other alternative is to walk in and just say, well, everybody knows that Hyder's a bad man, which everybody does, right, Hyder? Everybody knows Hyder's a bad man. Everybody knows he was kind of in control of that area, and there's a lot of burned homes and a lot of dead people in there. Therefore, Hyder's responsible. How do you feel about that, Hyder?
Not too good.
Now, why not?
Because I'm not a bad man.
Right. And because I bear the burden of proof as the prosecutor. Right? You're innocent until proven guilty. And anything other than that process is just power and lawlessness. See, it really, truly is, at the end of the day, about the rule of law. That's why it's important to document these crimes. Okay. So you have the widespread rebellion that spreads. And at this point in the stage, in early February, casualties are mounting very, very quickly as there are deliberate acts. And of course, there's a subsequent debate in the Security Council, both in the General Assembly and in the Security Council. Very important debates, because at this point the question is, what is the international community going to do? Either individually or collectively. Okay? As a political matter and as a legal matter. And it's at about this point that NATO begins to step in a quiet way and say, well, we have some capacity as NATO. Does this sound like Syria to you? And this is built on the Kosovo precedent. The problem is that it takes some time to do this politically. So here's the Security Council resolution, and this is fascinating.
Can I interrupt you?
Yes. Yes.
So before this happens, the Arab League,
Yes.
which can only make decisions by consensus, except for the country that is involved, passes a consensus resolution saying that we want intervention into Libya, right?
Yep.
And
It was critical because at that point you had Arab League members, remember, wearing their other hat as members of the United Nations, who are in the UN structure as a bloc, making the same kinds of statements. So in essence, it gave them some political cover
Do we have that
to
for
become
Syria?
involved. Nothing even remotely close. You have some scattered Arab League resolutions condemning, but you have no unified call for action in the same way as you did in Libya.
Why is that?
I think a lot of it is politics. A lot of it is frankly, the colonial pressure, the geography. Right, Libya is further away. It's a little more isolated. It's in the context, if you look at the map, we talk about the Arab Spring. You've got Libya, Tunisia, Egypt, all kind of right there, and that's part of that wave. Syria, geographically remote, and in a much more volatile part of the world. I think it's that much more politically sensitive. So, but it's interesting because this is the resolution that comes out, and notice this is way back in February, when the rebellion is really still very much building and it's in its early phases. And note that this resolution does not call for interaction, does not call for intervention. What does it do? The first thing out of the gate, let's refer this to the International Criminal Court. And here's the language. We wanted to refer the situation. And it's important here because of the temporal date. Notice the 15th of February 2011. Again, that's one of those flashpoints that's always going to be a subject of debate. We decide that, and this is important, decide that Libyan authorities, non-states party who have not ratified that treaty, have the legal duty, because of Chapter 7, to cooperate fully and provide any necessary assistance to the court. Now that's everything from letting them come and go freely to not arresting them, etc. But what doesn't that say? It's just a generic cooperate fully. It doesn't provide, and this was important after the fact, as Professor Scharf knows, specific diplomatic immunity to ICC people. It does not say that ICC investigators inside Libya enjoy the full range of benefits as any other state that has signed that relationship agreement as a formal document with the ICC. And this, of course, turns out to be a critical point because those investigations are hampered on the ground by domestic officials.
Let me ask you a question, Mike.
Yeah.
When the Security Council authorizes troops to go into a country or sends special representatives into a country, they get the privileges and immunities of experts on mission,
Yes.
right?
Yes.
If the Security Council authorizes, which in other words has deputized the ICC to do these investigations, why shouldn't the ICC investigators, defense counsel or whoever, get the status as experts on mission, which comes with privileges and immunity?
Because in every other context, when they're sent, they're not deputized. In every other Security Council resolution, when somebody goes in with a special status, it says so in the resolution. It says they get, in Kosovo, the status of administrative and technical privileges and immunities. Or in the case of a full out-armed conflict, like the Iraq resolutions, for example, or the Gulf War, the first Gulf War, is a different body of law. Here, imagine that the default rule is you have no immunity unless it's expressly granted and expressly conveyed. And there's a number of ways to do that, right? The court could make an agreement with that country. That's one way. The Security Council could refer to that agreement and say, we use our authority to put that agreement in place to cover those people. They didn't do that. They could simply say, here's a principle of immunity, and we hereby decree that that principle of immunity applied to those people. They didn't do that. And so that's why ICC investigators are very nervous about imagining in the future going into Syria to investigate without any baseline source of legal protection. That's the problem. And that has to be remedied. It really does have to be remedied. Yes, sir?
Could this baseline legal protection be a way to sort of reconcile the prosecution's
Good.
responsibility to sort of look into what's going on and with just mission accomplishment in general?
Oh, well, no. Listen, here's the issue. Good lawyerly question. Smart man. You should go to law school. Here's the issue, though. You have to learn to look beyond the obvious. The obvious issue is what protections do ICC people get while they're in the country? And it's easy to fixate on this side or this set of crimes. Here's the problem. absent any express legal protection, what happens when those same investigators start examining war crimes by the people that are now in charge? It's not, I need your help. You've got the legal obligation to cooperate fully with me in proving your own crimes and not arrest me and not hinder my investigation. You see, how about a resolution from the Security Council that says, we hereby decree that we want you to investigate just one side, one perpetrator, one set of crimes. Anybody vote for that? I don't, because that's not law.
And what's interesting temporally about
Exactly.
this is that it's since February 15th, but it's open-ended, so it continues.
Absolutely.
Today. Whatever is happening now is still within the jurisdiction of
Absolutely. So here's the simple teaching point is this jurisdictional thing, it seems like some little picayune. If you don't know what that means, look it up. It's a law school word. Some little picayune, technically hyper-technical thing, but I'm telling you that this issue, the express provision of immunities and immunity, essentially diplomatic immunity on the ground, has huge implications for how the court actually investigates and collects evidence on the ground. And unless you fix that, you're hamstringing them and creating the conditions in which they can't succeed. Accompanied by, look at paragraph 6 very quickly, which says, oh, by the way, investigate all of them, but not anybody else coming in. Okay? Now that's important actually, because remember, this is a political exercise. This is not a legal document in the sense that it's a legal exercise. And what it's really saying is, anybody who's not a state party to the ICC, who's that talking about? U.S. forces, okay, shall be subject to the exclusive jurisdiction of that state. Meaning, if some American happened to have committed a chargeable offense, that the United States retains jurisdiction. And you had to have that kind of language as the necessary predicate for building political support to go in and do anything. Again, apply that to Syria. If you're going to do something in Syria, you're going to need similar language. So that part is relatively uncontroversial. But within the state, you simply cannot begin to distinguish one side from the other, one party from another, one tribe from another, etc. You have to say, ICC, you have jurisdiction over everybody in that context, and we're going to create the conditions by which you can succeed. And again, the point is, unless they fix that issue, they haven't done it. They've created the conditions where they're hamstrung. A quick question from the back.
Sir, I understand, bear with me, I'm kind of ignorant to the international law, I'm new to it. Isn't diplomatic immunity customary international law? Isn't that something that doesn't need to be expressed, that all countries should recognize?
Sure, but when you have the official status on behalf of a country, but you see the ICC is its own unique animal. They're neither diplomats, nor are they the representatives of a particular state. That's where they need a special status. It'd be like if you signed a contract to go into Afghanistan tomorrow to provide some technical legal advice, you're subject to full Afghan law, unless there's an express prohibition of law that gives you some exclusion. So that's the problem. You've got to provide for that.
I don't want to get ahead of your lecture, but are you going to tell them about what happened with the Defense Council?
I am indeed.
Okay.
Yes. Well, let's go ahead and tie that together now. So defense counsel are going in to interview their clients, and lo and behold, what do you think happens? I should watch the news once in a while. Yeah, you should watch the news. They're arrested and detained. And in fact, the materials that they're carrying back and forth, right? Who wants to be a defense counsel? Do you want the jailer, when you go in, taking all of your materials and your confidential communications? And they're arrested and charged with, drum roll please, espionage.
Now, I have to...
They're coming in and spying. This is Melinda Taylor, a friend of ours.
There is an LLM graduate 2 years ago who is now the chief, this is from our law school, he is the chief investigative judge in the Saif Gaddafi case. That's Colonel Gaddafi's son, the #1 person who the ICC wants to prosecute. When I was in Libya was exactly when this incident occurred. And Melinda, who is someone we both know, a defense counsel, but she's even closer because she's best friends with Chris Rossi, another one of our graduates, and Kate Gibson, his wife. And so it's somebody we know really well.
Yeah.
She was down there to talk to her client, who's going to be prosecuted before the ICC. There's an indictment now. And they, as Earl said, they took her into custody. And I asked my former LLM student, what's the story? What's going on? And he said, well, here's the story. So they're really scared in Libya that he is going to take all the vast money that Gaddafi stole from the Libyan people. And by the way, if you go to Libya, one of the weird things you'll see are these entire cities that are half built in the middle of the desert. And what happened is the government would decide to employ the people by building a giant city, and then people would corruptly steal all the money, and the money was just funneled out. The city would never be completed, and it's a weird attribute of corruption. As you go through Libya, that you see all these like ghost towns that are really modern, but they're just half built. They're like the in Star Wars, the Death Star, you know, the half built. Anyway, so I said, well, what's the story? Well, there's billions and trillions of dollars that are hidden away in bank accounts, and they want that money eventually to come back. And they're scared to death that what he would do is pass the bank account information to his defense counsel to move them. And so it seemed like she was asking him to sign certain papers. He was giving her information. They were worried about it, so they grabbed her. That was the story.
And she had her little spy camera, so she fit that in part of the profile.
Was that true about
It
the
was
spy?
true. It was true. But, you know, here's the real point is that ISIS investigators, who already have an incredibly difficult job, remember, they're working against the backdrop of not having anybody hand them a case file. Here are dates, times, places, events, commanders, all the things you need. It's an unbelievably difficult job. This legal oversight is a technical legal matter, hamstrings them to a great extent. Heider, let me make this last point quickly. Paragraph 7 gives you, and watch this as Libya involves, the continuing prosecutor reports to the Security Council. Very important. Paragraph 8, the fatal flaw, the Achilles heel. We're going to have you do all this, and we're not going to pay 1 penny for it. But again, understand, this is a political document. This is a political compromise. What do you think the chances of getting this resolution at that point of the conflict if non-member states, read the United States and China, have to pay for this whole investigation? What happens? Doesn't make it through the Security Council as a political matter. But conversely, from the perspective of the court, had this incredibly difficult job under difficult circumstances, made more difficult by your Security Council resolution, and I have to take it out of my own extremely limited resources in a zero-growth budget environment. Very, very, very difficult. And again, my point is simply to say that unless that issue is addressed in some way in future resolutions, my prediction is this may very well be the last resolution. Because in the future, when they go and they say, Madam Prosecutor, we'd like for you to take another case, realistically her answer is, fine, come back to me in 2 years, 5 years. And to the extent that she says, yes, okay, fine, put Syria, put Mali, put these other cases on my docket, by virtue of Security Council authority, there's an opportunity cost. That means that existing cases, they just don't have the resources. And this is a huge problem. Okay, question, quickly. I thought I saw a hand. Hi.
Why do you suppose the Security Council did leave out an express provision conferring diplomatic immunity on ICC officials?
It was a pure oversight. It is the habit. You know, these cut, I don't know how you say it in Arabic, cut and paste. You know, the idea, well, we haven't really expressly thought about it in the context of the ICC before. We darn well better think about it now. Our experiences in Uganda saw the same thing. The Ugandan political officials at lower levels. Because remember, this is kind of sensitive. It's like me driving up when you're the mayor and saying, yeah, I'm going to investigate you and your police forces, and by the way, you have the legal obligation to cooperate fully.
I have a more cynical take on this, believe it or not. I think that you have to look at the International Criminal Court when it's being referred cases by the Security Council as a very political arm of the Security Council. And so it is quite possible that the Security Council did not want or intend the ICC to actually do investigations. They didn't pay for it. They didn't immunize the people to do it. What they wanted in the middle of the crisis was to stigmatize the regime, to give credibility to what they were doing, which is these armed attacks, especially since they were controversial. Because if you remember, the Security Council resolution on the use of force said that the Allied forces could use force against the Libyans to stop the crimes against humanity, to stop the attacks against the civilian population. But that's not all they did. They were attacking the heck out of the regime to support the rebels so that they could have regime change. And the Russians said, this is wrong, you've gone too far, and it was very controversial. By having this resolution, which then further stigmatized the regime, it gave them the political clout to continue the bombing.
I agree, except the timing is backwards. The ICC referral came in February. Resolution 1973 that authorized NATO involvement didn't come until March.
Well, okay.
So I don't think the Security Council has that much together. They're not that good, actually, to plan ahead of time.
But even if the ICC prosecutor didn't do anything in Libya, and they haven't really done anything in Darfur,
Right.
you still have this indictment. In
Absolutely.
theory, you turn the regime into prisoners in their own state, you give credibility to the opposition, and that is part of what is meant by this vehicle.
Exactly.
I think often these tribunals, when they're being set up, there's not really a thought that they're going to achieve, the goal of getting the leaders. When they created the Yugoslavia Tribunal, they didn't think they were going to get Milosevic and Karadzic and Mladic. That day finally happened 20 years later. Nobody really thought that was going to happen at the time. And yet they thought creating the tribunal was important symbolically for the political effort of isolating the regime and trying to get regime change. And I think if you look at these referrals, not in terms of the actual practicality of getting the bad guys to the Hague and prosecuting them, but rather a first step that stigmatizes them, then
I think that's all true, but it reinforces my point, which is to say, to the extent that the Security Council comes out ahead of time and says, oh, by the way, don't worry, this is all politics, we really don't mean it for them, what have you done to the court itself? You've eviscerated the ICC. And that's why they won't say it. And to the extent that now, twice, in both Sudan and Libya, you've signaled that this is all politics, it's really not serious, it's criminal prosecutions, don't worry about it. You've really, really hampered the effectiveness of the court moving ahead. That's why I think they've got to address this problem. You can't have it both ways. You can't say, hey, the ICC is all about law, it's all about regularity, it's not just politics, which was the Milosevic argument. Hey, you just set up this tribunal, it's all NATO Western politics. The treaty and every other scholar out there says, no, it's about law, it's about regularity, it's about ending impunity and equality before the law. But to the extent that the Security Council continues to signal, yeah, it's really all about politics, that's a fatal flaw going forward.
But on the other hand, looking at the Darfur situation, where in the Sudan, it's the same thing. They referred the case to Sudan. Sudan is not a party to the ICC statute because of the genocide in Darfur. The president of the Sudan and his assistant, Haroun, have been indicted by the ICC. Now, these guys, especially the president, have been hopscotching around Africa, and nobody has taken them into custody. He's even got in China, a permanent member of the Security Council. China didn't take them into custody. And it flouts the ICC, and it makes the ICC look weak. But you know who really looks weak, in my opinion? It's not the ICC, but it's the Security Council. If the Security Council is going to refer a case to the ICC of a non-party state, then the credibility of the Security Council more than the credibility of the ICC is at stake. And I think that's also what's going on in Libya.
I absolutely agree.
But they don't see it that way.
I absolutely agree. And that's why, remember the teacher point, this model of the resolution is not sustainable as a long-term model. Okay, so we move into the conflict, and Professor Sharp is exactly right. At this point, you have Resolution 1973, you have NATO involvement, arguably going beyond the scope, right? The resolution specifically said, provide humanitarian relief, protect civilians, okay? But over time, it's very, very apparent that what's really going on is regime change. This is just a quick schematic of the areas of rebel control. You see the rebels begin to win. They begin to push across Libya. We all know how this ends. The Gaddafi warrant for arrest comes out on June 27th, which is really important. Notice the timeline, from February to June. In ICC terms, that is light speed. In ICC terms, that's like snapping your fingers. So there's 2 points associated with that. One, remember that they didn't have this pre-existing, really good documented database of criminal acts. In other words, arguably, they made it up. Very, very, very weak evidence. This case is not ready for trial. And if Gaddafi had been smart, maybe as his defense lawyer, you would have said, call their bluff. They're bluffing. Go in right now. Move that case expeditiously. Call their bluff, because are you better off in the hands of an ICC that has now issued a warrant of arrest for you and really doesn't have a substantial case, or are you better off in rebel hands? As a defense counsel, I might have that conversation with him. Of course, we all know how this ended. Question?
I'm sorry for interrupting your presentation.
No. That's a dialogue, dude.
So perhaps the reason why they just issued that warrant of arrest without really having the evidence that you're talking about is maybe because of past precedent that was set by the line of death that we talked about in our international law class, where Gaddafi said that no one can fly in this territorial area in the United States, put an aircraft carrier nearby. Is that perhaps maybe the reason why the Security Council and the ICC was quick to jump the gun for issuing that warrant?
I don't think so. Just different apples and oranges, different era, whole different body of law in the line of death. Where are we all? You remember where you were standing when you heard that we had bombed Libya? I do.
2 years ago?
No, back in '83.
They weren't born.
But I think this is an extension of Professor Sharp's argument. This is politics. And this is the court very quickly moving to become relevant, to become the center, because from the court's perspective, what they're worried about is being marginalized and having their influence, such as it is in the region, overcome by events. They're trying to quickly establish, it's like as a defense counsel, when you're the first to begin filing motions, you want to set the terms of the debate, and you want to be relevant in that debate. That's why, as a defense counsel, you're among the first to begin filing aggressive motions. That's really what they're doing. And at that point, the ICC has an inalterable, inarguable role in the resolution of the conflict. Because now there's an outstanding warrant of arrest and an international duty springing both from the Security Council resolution and from customary international law for other states to do something. One more thought. That's why this is important. Note the charges. That's why it's so important that they didn't charge him with war crimes. Exactly. And by not doing that, you lost the basis to go to other states and say, it's either you or us under international law. You have the legal duty to do it under international law for these war crimes, or you have the legal duty to extradite this person and all those henchmen to other states that will do it. In the absence of that, send them to us. That's our role in the world. And I think that's what's going on beneath the surface, is they missed that opportunity. Michael.
To put the issuance of an indictment and the timing of that by an international tribunal in the context, I want to tell you another story about my movie, which you'll find, I think, very insightful. In 1999, the United States and the NATO countries were bombing Serbia without Security Council authorization to stop potential ethnic cleansing in Kosovo. And during this 88-day bombing campaign, there was not an indictment of Slobodan Milosevic. In fact, prior to this time, the United States had signaled to the ICC that it would be unhelpful for there to be an indictment of Slobodan Milosevic, the president of Serbia, because we need to negotiate with him for the ultimate peace, and you can't negotiate with someone who's under indictment. Now, in the middle of this bombing campaign, the bombs started going astray. They landed on the Chinese embassy. They landed on aid convoys. They started killing civilians. And there was a lot of complaints throughout NATO countries. And suddenly, there was a good chance that some of the countries of NATO were going to pull out, and that the entire campaign was going to fail, and potentially NATO itself would be dissolved over this. So what the United States really needed was for Slobodan Milosevic to be indicted in a hurry. So what do? They send Michael Newton, who is the deputy to the ambassador at large for war crimes issues, with a big box of evidence that the United States had not previously turned over. That was sort of the smoking gun intelligence that would help them seal the deal. They give it to the prosecutor, Louise Ardor of the ICC, and almost immediately thereafter, an indictment is thrown together. An indictment which, by the way, is even crappier than this one, right? It was not a well-written indictment because they had not pursued the indictment.
Exactly.
And all of a sudden, the United States said, we need this right away. I have no idea what we told her, but it must have been very effective. I don't know what the statute of limitations on that kind of conversation is. I know she's talked about it a little bit in her book. But anyway, I think that this is the same situation, that the fact that they hurried up and did this indictment was because of political pressure for them to do so, from maybe not the United States, but other countries, Great Britain and France in particular.
I actually have a different theory in this context, and it really had to do with the ICC not wanting to be marginalized. They wanted to be a key player and the key voice in determining what happened into the future. Because remember, this is while the war's still going on. Not quite sure what's going to happen and how it's going to be resolved. And it's also absolutely while the Libyan judiciary is in chaos. Right, there aren't courthouses, the Libyan structure is in chaos. And the ICC really sort of stepped forward. It's like the girl that wears the really loud yellow dress to prom and says, "Here I am!" Right? Don't miss me! It's the ICC assuming center role in this process. And I think part of it, too, was because of what had happened in Sudan. You see, when the political process essentially ran past the court. Here, they took that opportunity very quickly to put themselves, which is the really important issue going forward. And you probably worked on this some. I've worked on this in The Hague. Professor Sharp has worked on this. And it's this issue going forward. You've got a brand new Libyan society and a brand new restored Libyan judiciary that says, okay, we're here, we're back. These crimes were committed against our people and our citizens. We're the ones that bled. We're the ones that suffered. We're the ones, you know, in the good old American tradition, that fought and won our independence from the tyrant. Not that King George was all that bad in historical comparison. But by golly, justice belongs to us. The trial of Senussi, despite the fact that he is indicted and warrant of arrest is issued, has begun in Libya today. And so today, the issue going forward is this struggle for control between the domestic officials and the court. And this is a big issue because the court put its stake in the ground early and said, we're the central player here. The Libyan judiciary has come back and said, oh, no. We are the central players here because they're our people, because they're our homes that were burned, etc. And that's the struggle today going forward.
One more wrinkle to this. In Libya, they have the death penalty.
Yes.
And they want us to, if these people are convicted, they want to execute.
Yes.
And the ICC does not have the death penalty. Now, the ICC has something called complementarity. And there's a theory that the former prosecutor created called shared complementarity, which was, instead of looking at it as either you or us, either you prosecute domestically or we prosecute internationally, why don't we share it? We'll take some of the most controversial high-level people and prosecute them in The Hague. You take the others that we've indicted that are a little bit lower down that we think you're capable of handling. This was the theory. Now, it hasn't actually been implemented, but in a case like this, it's almost impossible to implement because they have the death penalty at the domestic level. So that takes that option off the table.
Yeah. Well, and then, you know, what's really, here's the key point for you to watch. What's going on the ground in Libya really does have really vital ramifications for complementarity. This idea of a shared cooperative jurisdiction and a cooperative relationship going forward. And again, why do you care? Because I guarantee you there will be other situations where this is controversial. There already are. And that's going to be the trend in the future, where this struggle for judicial authority is very, very difficult. Okay. Now, we haven't talked yet about U.S. war crime stuff, which we will, or U.S. War power stuff, which we will. And we haven't yet talked about U.S. bureaucracy, which we will question.
Is this same situation being set up right now in Syria, where there's going to be a conflict between the Syrian judiciary and the ICC with it?
Yep.
I'm just not sure if Syria has, if after the regime change is going to be a similar post-war infrastructure.
Yep. Yeah. And to the extent, again, you know, this is part of my point about U.S. bureaucracy and our own bureaucratic structure, which is linked to UN structures, which is also linked to the overarching agreement or how the conflict actually ends. What's the modality, to use the law professor word, the way we actually end the conflict? Is it a peace agreement? Is it a ceasefire? Is it a Chapter 7 imposed solution? Is it a regional solution? In Syria, you may very well have the Arab League that negotiates some binding agreement. And all these elements, in some way or another, bear on the contents of that agreement, and more importantly, how it's implemented. Because remember, the goal is, we just went through this terrible period of human suffering and armed conflict, and the whole point of all this stuff is not to have the lawyers sort of intrinsically interested, but it's to build lasting peace. To the extent that we don't get all this stuff right, we're actually undermining our real efforts to build real peace. Okay, quick question. Yeah?
This might be getting a little too deep into the procedure, but this issue of shared complementarity, if I remember correctly, the Rome statutes either in places explicitly, in places implicitly says we give the prerogative to the local jurisdiction, and unless they are unable or unwilling, will we then take over.
Right.
is it then possibly setting up another maybe political debate or political fight over the Rome Statute where you have the Libyans who want that, but you have this in sort of where I guess maybe it's another issue of Security Council problems of who then takes precedence, or are we just setting up for another stalemate?
You're setting up for another stalemate because what really happens is the ICC has to go into that country to collect evidence, to get witnesses in and out for a whole range of things, and it's very problematic. If anybody looking for a thesis topic right now? Great thesis topic. I was just in The Hague back in the fall in the Peace Palace, and the question for this particular panel was, what should the ICC appellate ruling on that issue be, on the real meaning of complementarity? And how do we structure that in a way that satisfies both sides? This is as Professor Sharp would say, Libya is hot, hot, hot. That is a white-hot legal issue, which has dramatic ramifications, again, for future practice. Okay, this is a big deal. This is a big, big, big deal. Okay, so you all know the rest of the story. Rebels win. International armed conflict ends. And again, one of my pet peeves, because I was in Iraq digging up mass graves all over Iraq, and in Kosovo digging up the mass graves. You have got to get the forensics experts in early. Anybody remember in the aftermath of Benghazi how long it took the FBI to get into Benghazi? Weeks and weeks and weeks and weeks and weeks and weeks and weeks, and they never, ever really got in with the right expertise in the right place to do what they needed to do. And I'm telling you, as a matter of U.S. policy, that is a critical structural flaw. We have to have, and here's my soundbite on this. I've said this on CNN a lot, but here's my soundbite for you. What we need is not brigades of bureaucrats. We are so bureaucratically paralyzed in the way we mobilize these resources and the way we insert them and where we send them and what their resources are. The struggle between the Department of Defense and the Department of State and the Department of Justice and the Deputies Council and the NSC, the National Security Council, and the Secretary of State and the U.S. Marshal Service and the Marines who have to go in and protect these people. We cannot do this unless we do it rapidly. Now, we did this in Kosovo. We did this in Iraq. We did not do it in Libya. And so it's after the conflict that we then have to go and do the forensics. The problem with that is we're not there to do it. We are not structured. So the soundbite is we don't need brigades of bureaucrats. We don't need billion-dollar programs. What we need is decision-making and leadership and the ability to get the right experts, very few experts, very lean teams, into the right place at the right time very quickly. Otherwise, what we're really saying is, we want you to prosecute these crimes, but we're not going to do diddly to help you. We're just going to let you do it yourselves. And I don't think that's the right answer. Not if we want to have any role in really shaping the future, in this context of Libya, in the future of shaping Syria. We lose our influence, we lose our leadership by being bureaucratically paralyzed and unable to do this. And this is a big deal, again, because we don't have the structures to do that. And we've known about this problem now for close to 2 decades, and Libya dramatically demonstrates that we haven't solved it at all. And it's even still now, when Professor Sharp is there, he's there in a private capacity. You know, that formal support coordinator role built into those structures where you've got U.S. experts, both forensic and criminal and investigative and police, really allied with them, working with them right up from day one. We don't do it. So we stand back and we preach, build the rule of law, respect human rights. But it's like your parents preaching at you, wagging their fingers. Unless we're able to go in and help them with lean, effective programs, it's all just talk. It's all just politics. Okay? And I think that's a really critical lesson for Syria.
Like our law librarian.
Oh, I'm sorry. I didn't see you sitting there.
Okay. What's the perspective of the average Libyan on the street do? Are they really concerned about justice, or do they want to just get business going?
Oh, yes, they are. Let me give you my soundbite on this. Libya, Kosovo, Iraq, everybody asked me the question, and they ask each other the question, okay, we've been through all of this struggle. All of these people have been killed. All of these homes have been burned. What's it all about? Why? And the Security Council says, well, it's about freedom, it's about democracy, it's about human rights, it's about restoring control over yourself. They don't give a fig about all those big picture things. What they care about is an immediate functional change in their life. And so here's what I say about this, to answer your question. You have to have 2 timelines. Everybody in Syria, for example, needs to see some dramatic change in the first 30 days. Secret police stop investigating people and stop taking you off in the middle of the night. That's a good thing. Right? Big changes. In Iraq, I think the future of Iraq would have been different if we had been smart enough to have all the electricity on in Baghdad in the first week. And it's some big, tangible, big demonstration, right? The old regime has ended. The Iraqis called it the entombed regime. It's been dead. It's been buried. The entombed regime. And this is a new Libya. So what they care about is tangible. You know, there's food and fruits and vegetables and whatever's specific for the context, right? Maybe it's a country where we had no freedom of movement, and now we can move. We can go. We can visit our relatives. Whatever the change is, there has to be dramatic change very quickly. What that does is it buys you the building space and the breathing time to get the popular support and the goodwill to build the long-term big picture stuff, to build the judiciary, to build police, to build the immigration services, all the big picture organizational stuff. That doesn't happen overnight. But you got to have cooperation of people and the breathing space and the patience to say things really are different. And we like it. We like having electricity and fresh food and whatever else happens. But it's got to be very quick and dramatic. Yes, sir.
To illustrate how difficult the challenge is to make this work. When I was in Libya, I went to Misrata, which is the one town that was the worst devastated by the pro-Gaddafi regime troops. And there's a town near Misrata that all these troops came from. And as you enter Misrata, there's a giant sign on the side of a building that says, "We will never reconcile with the people," I forget what the other town is called, but with the people from that town. And it's not in English, it's in Arabic. And so when we're going in there, we're going to be talking about their new Truth and Reconciliation Commission. And I'm thinking to myself, wow, this is going to be quite a challenge, because these people do not want to reconcile. They're still so upset by what they suffered. They're not ready to take that step. And so the idea that you use justice and you use truth commissions to try to move the population to a place where they can reconcile is in theory a great one, but it's really hard to implement.
And it takes a very, very long time, sometimes generations. But that's why I think you really do have to do big things early. If I'm talking to, and if I'm advising policymakers in the Syrian context, I say, you decide on what the big thing is. In Kosovo, the answer was, for example, Kosovo Albanians could never have their language in public. They couldn't be educated in Albania. They had to go underground. The first big thing you do is you don't just pass the documents that say everybody's equal. You open up Kosovo schools. In Afghanistan, one of the huge things that's made a difference, of course, as we all know, was educating women. Boom, big change, really fast, sometimes controversial, but what it says is, that was then, this is now. And it's got to be big, and don't forget, you know, we're lawyers, we like to think about rule of law and human rights and these big fluffy ideas. Those are very important. What do people care about? Food, fuel, school, health care, etc. Taking care of your family. That's what you care about. To the extent that we in the international community say, oh, those things, those are very nice, but those are kind of side. What's really important is human rights and rule of law and justice and all those things. We're blowing. We did it in Libya, and because we didn't move quickly enough to show really dramatic change, this is my point about paralyzed U.S. bureaucracy. So we can't do it, we're paralyzed in the U.S. bureaucracy, fine, we'll let the UN do it. You may vote for that? No. You see, we've got to get ahead of this. We've got to change that culture. Otherwise, we're creating the conditions where it's a lose-lose. We don't fundamentally change the culture from the ground up quickly, nor do we create the conditions for success where we can actually change the bureaucratic structures longer term.
Let me ask you a question that gets you back to the issue of the War Powers Resolution, which you haven't really tackled, but we only have a few minutes, so I'll let you do that in your last question. All right, so during the presidential debates, both candidates, including Obama, said, we will not commit troops or create use of force in Syria territory. But you know what? Looks like they might want it. They might want to do a no-fly zone. They might want to do something else to create safe areas. I mean, as things just get more and more bloody, they might want to do it. Right. Let's say Congress doesn't approve it, so they don't go and seek congressional approval. What does Libya tell us about the power of the president?
Very good. Here's my soundbite on that. Two things in 2 minutes, 1 minute. One is the technical argument which you assumed. Everybody knows, if you don't, the War Powers Resolution on its face is an act of Congress that's specifically focused on the introduction. The point of the War Powers Resolution is big bodies of people, big bodies of troops, which requires sustained effort. And the point of Congress was to say, hey, we're the representatives of the American people. And to the extent that you, the President, are going to send a whole bunch of our American people into a conflict zone, we've got a voice in that. We have a proper and a democratic society. So it's really focused. Now, by the technical argument, first thing it would be to say, well, but that doesn't have anything to do with drone strikes, aiding and equipping, all these other ancillary things. And that would be the President's technical argument. That's what he said in Libya. I'm not introducing ground forces, hence War Powers Resolution, not relevant. I think that's a fundamental mistake. It might be right on the law, on the technicalities of the law, but here's my big point about the War Powers Resolution. What the War Powers Resolution is really all about is the President taking leadership to mobilize the American population and to an extent drag the Congress along as the representatives of the American people. This concept of leading from behind is rubbish on the international domain, but frankly, what I really care about for my business is the U.S. domestic domain. To the extent that the President is not right now in the Syrian context, for example, let's assume he does want to provide arms and equipment to people. He needs to be making that case to the American people, who he represents. That's the point. Is the President, and presidents going back for 50 years, have hidden behind, the War Powers Resolution was passed in 1973, what's that, 40 years, almost 40 years. Have hidden behind the technicalities of the War Powers Resolution not to aggressively, affirmatively make their case to the American people. That's the lesson I draw. That's the fatal flaw in Libya. To the extent that you don't make that case, you may be right on the technicalities of the law, but you're also fatally undermining the ability to do what it is you want to do on the ground. And I think that's the lesson of Libya. You have to make that argument affirmatively and aggressively and clearly. Otherwise, you're creating the seeds of unsustainability. Why don't we have big, effective programs in Libya today? Because the American people aren't on board with that. Neither is the Congress. And if we want to get it better in Syria, the President better take the lead in making that case and convincing the American people of the American interest. Otherwise, what's the point? It's form without substance. And that's what I want to leave you with. That's my bottom line. Form without substance. All these things may look great. We did something. We referred the case to the ICC. But if you don't create the conditions of success in the reality, it really doesn't mean much. So thank you for your time and enjoy the rest of your day.
And please join me. See you at the next Tax Center event. Enjoy your weekends.